Good morning and welcome to this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. My name is Surisha Ganta. I'm Counsel and Education Director with PBPA, and I'm excited to have with us today Tracy Johnson-Marr, who is Principal at Jackson Lewis, and she is going to be speaking to us today about understanding Georgia's unemployment security laws and how they specifically apply to Georgia nonprofits. Before Tracy gets into the substance of today's topic, I want to take this opportunity to tell our audience a little bit about PBPA. The mission of PBPA is to provide free legal services to community-based nonprofits that serve low-income or disadvantaged individuals. The way we do this is by matching eligible nonprofit organizations with volunteer lawyers from the leading corporations and law firms like Tracy's in Atlanta who can assist nonprofits with their business law matters. In order to be a client of PBPA, an organization must be a 501c3 nonprofit located in or serving the greater Atlanta area, serving low-income or disadvantaged individuals, and otherwise unable to afford legal services. If you're interested in more information about our organization or to apply to be a client, please visit our website and fill out the request for legal assistance application. Also on our website, we have a host of resources available to any Georgia nonprofit. This includes articles, past webcasts, podcasts, and in the future, we plan to be hosting our live in-person workshops again too. And now a quick disclaimer. Today's information that Tracy will be sharing is just general information. It is not specific legal counsel. If you have questions about your organization's specific situation, please reach out to an attorney. And now, Tracy, I'll hand it over to you for the substance of today's presentation.
All right. Thank you, Surisha. Good morning, everybody. I am happy to be here and talk with you all about the very titillating, exciting world of unemployment benefits. It doesn't seem like it right now, perhaps, but when the time does come that you're faced with having to terminate an employee, separate someone, and you get that claim in the mail that you're being asked to provide unemployment benefits, and what do we do? There really are some things that we should think about in advance, that we should be aware of in advance, especially when you've got a circumstance with an employee that you really truly believe is not entitled to unemployment benefits, that there was a good reason for that person being separated from the company or from your organization. So we're going to talk generally about what are the rules on who's entitled to unemployment insurance. That's what they call it in Georgia. What's the key information when you are that you need to present when you're dealing with the initial claim? When is it important to fight? And I get these questions a lot. A lot of times I have employers who say, listen, I don't think this person deserves any unemployment. They were a terrible employee. They didn't come to work on time. They couldn't do the job. You know, when can we fight? I'm going to fight this. And then we get the disappointment where they try to fight it or choose not to fight it ultimately, and the employer comes back and says, I can't believe that they gave them unemployment. You know, what went wrong here? It's such a no-brainer. I don't understand. And so we'll talk today about how it's a little bit more than a no-brainer. We really have to be very strategic a lot of ways, and a lot of that strategy comes from when the person actually first starts working for you or even before that, and we'll talk about that. When you do fight, what happens as a part of the unemployment hearing process? What should you know? What should you do? And what are some ways that we can manage unemployment compensation costs? So we'll go ahead and get started. And we'll go ahead and get started this time. So the basic question, what are unemployment benefits? Well, basically, these are benefits that are provided by the state through taxes that employers pay into the system. It's that FUTA, the Federal Unemployment Tax that is being provided into the system. It comes out as a part of the what we pay our employees, and we tax a part of that. It's about 2%, 2.7% I think now in Georgia, that we take out of their pay, and it goes into this fund. And when there is a claim against the fund, there's a claim against the employer for those benefits, the state pays out those benefits. All employers do have an obligation or some obligations under the Georgia unemployment security laws, but we're not all required to pay taxes into the system. And I'll tell you just a moment about what it is about nonprofits that might give you the ability to not have to pay into the system. If you haven't set up an account yet, after we get through the end of this presentation and you recognize that you really should have an account set up, you should probably reach out to your employment counsel to make sure that you're doing the right things and that you're that you're not going to be found and caught unawares if someone makes a claim for unemployment insurance. So, big question. Are nonprofits required to pay unemployment taxes? The short answer is yes, but there are some requirements that you have to meet. You are required to pay unemployment taxes into the Georgia system, or really any other state system, if you have at least 4 employees who work some or part of a day in each of 20 weeks during during a calendar year. So if we're looking right now at the question of whether I have to pay unemployment taxes, I haven't done it yet. Do I need to do it? I need to start counting how many employees do I have. And by employees, I mean full-time, part-time, sometimes long-term, temporary. It doesn't matter what their status is for purposes of identifying and knowing whether you have to pay unemployment taxes. The state does not make any distinction between those statuses. The question is, did you have 4 or more people working for you? Were they doing any sort of work? Then they're going to be employees, and you're going to be the employer for purposes of when they go file a claim for unemployment benefits, your organization is who they're going to come back to. So that's number 1. Number 2, Georgia only recognizes nonprofit organizations if you have a federal 501(c) exemption. Those are the only ones that Georgia will recognize and will allow you to come under its lesser criteria. And what I mean by lesser is, unless you are a 501(c) status employer, you would otherwise be required to pay into the unemployment tax system if you only had 1 employee, only 1. So at least one of the benefits that you get of having that 501(c) status is that you at least have to have up to 4 employees in order to be a part of the system. This third bullet point is where a lot of folks get tripped up a lot. And that is, they say, well, I don't have employees working for me, I have independent contractors. And so we don't have time today to get into the myriad of elements that it takes to demonstrate that a worker is in fact an independent contractor. The fact of the matter is, and I want you to take away from this, is that independent contractor status, according to the Department of Labor, according to the IRS, is a very high bar to reach. It's an extremely high bar to reach. There is a multi-factor test that you have to demonstrate and meet the elements of that test to say that anyone who works for you should be deemed an independent contractor. And so if your presumption at this point is that you only have independent contractors working for you and therefore they're not your employees and you don't have to pay into the unemployment tax system, please have someone look at that for you, because the likelihood is that they may not be independent contractors and the Department of Labor might deem them to be truly your employers for purposes of counting whether you have to pay into the system. So the answer is yes, again, you do have to pay if you meet those criteria, but be careful about how you're counting employees. Next
question, Tracy.
Yes. Mm-hmm.
Just going back to the comment about independent contractors.
Yes.
If the worker says that they're an independent contractor, then can they be considered an independent contractor?
No. It's a good question. The answer is very simple. It's no. The test looks at various things. One of it is that independent contractor, that worker, doing something that is central and key to what the organization does? So for example, I'm in a law firm, and if I hire someone to come in and practice law, they do what we do. Independent contractors, I like to give the example of, an independent contractor, someone who has complete control over their time, has complete control over how they do the work. They typically are people who don't do something that is central to what the employer does or central to what the organization might do. And so, for example, you might have someone where you do not have an accounting department. You may have someone who could be an independent contractor who can come in and do some bookkeeping for you. But that person has complete control over everything. There should be a separate agreement with them about what it is and the services that they provide. It should not be a salary. It should not be some sort of a set fee. It can be a set fee, but not that, you come in and we pay you $1,000 a week. It has to be tied to what it is that they're doing for you, and that you don't have someone who sits in your office or who works for you that does something that is the same or similar to what that person is doing. So independent contractor status, and those are just the big ones, the big points that we have to look at. It's really difficult, and you cannot take someone's word for whether they are an independent contractor. It's beneficial for them to be an independent contractor because they're not taxed in the same way as an employee, but that doesn't mean that makes them an independent contractor. You need to look at that on a case-by-case basis. Does that answer your question?
Thank you.
Okay. Sure. What's another benefit that we get for being a nonprofit organization? One of the other benefits that you get is you have the ability to pay into the system on an as-you-go basis, meaning with each of your payrolls, and you do that quarterly for paying into the unemployment system, or you have the option of being a reimbursable employer, meaning you can opt out of the system. You can let the Georgia Department of Labor know that you're opting out, but what it means is that the Georgia Department of Labor would agree, because you meet the qualifications of being a nonprofit organization, the Department of Labor would agree that if you have a claim for unemployment, it will pay out those claims and you then reimburse the Department of Labor. Right? So you are allowed to then reimburse. The thought of that is, we understand that nonprofits are going to have, not going to have the same budgets, if you will, the same abilities to necessarily pay for these, for unemployment claims as they come along, not pay into the system for each employee that you have on that quarterly basis. So they recognize that is likely, and that may be the circumstance. So there is a provision that would allow a nonprofit organization in Georgia to do a reimbursable program and to enter into that as opposed to that regular contribution. And you should explore that if that's something where you've got, you have low unemployment, you've got low claims typically, and that the reimbursement is a better fit for your organization, perhaps based on when your funding typically comes in. And so that is something that you might want to consider. You can talk with the DOL about that. You can talk with PBPA about that as well. But that is a benefit of being a nonprofit. Once you go into the profit sector, then that benefit goes away. So who is eligible for unemployment? There are a number of factors that go into that. You know, what employees are allowed to get and claim and get unemployment benefits. Well, they had to have earned enough money in the base period. If any of you have ever completed the Georgia DOL Form 800, that's the separation notice, you will see that there's a section on there that asks, has this employee earned X amount of money? Currently it's $7,300. That's what the Department of Labor needs to know in order to see if that employee is eligible for benefits. Did they have enough earnings within the base period? And I won't get into all of those technicalities, but did they have enough earnings in the base period for them to draw on unemployment? The second bullet point, the employee has to be unemployed through no fault of their own, and we'll spend a little bit more time on that because that becomes the big issue as to whether they're entitled to benefits. The employee has to be able to work, and so if you've got someone who's gone out on a disability leave, or if you've got someone who can't work because of a health or medical condition, then they're not going to generally qualify for unemployment benefits under Georgia law. An employee who stops working but goes into a valid training program, and that training program is one that's going to be prescribed by the Department of Labor and identified and agreed that that's a training program. Those are people who may be entitled to unemployment benefits, but it will depend on that program. So that's the start of eligibility. Do you qualify for those benefits? Employees who resign typically are not allowed to have benefits. I'm leaving, I'm going to go to college. I'm leaving because I'm going to go look for a different job. I'm leaving because I want to spend, you know, the winter months in Hawaii. Right? So those are not typically reasons that are going to allow you as an employee to earn unemployment benefits. But the Department of Labor does recognize that there are some circumstances, and it has to be a very good work-related reason as to why an employee would voluntarily resign employment and they would still be eligible for unemployment benefits. And so some of the examples that I've given you are, there's a material change in the working conditions. One example of that would be, an employee who normally works the night shift, so that, his wife works during the day. He stays home during the day to take care of their kids who are not quite school age yet, and so when she gets home, then he works at night. And the employer says, you know what, we're getting rid of the night shift, and or we're doing a rotation system such that even if you work the night shift, at least once a month, once a week, whatever it might be, you're now going to have to work a day shift. All right, so the change happened in the working conditions or the working agreement, which is the same, kind of the same in part too. The Department of Labor will say you are eligible for benefits if you resign because you haven't been paid for the work that you've been doing. They find that to be a qualifying reason for stopping work and for qualifying for benefits. When we talk about a good work-connected reason, those are the things that we're really looking at, and that's what the Department of Labor is really looking at. But even if it's a personal reason or it's a good reason, for example, when we go back to the one with the guy who's taking care of his kids during the day, if he says, now my wife's job has changed and I can't do it, and the company says, well, we're willing to work it out with you so that you can work. He says, well, no, I really prefer to do it this way. It might be a good reason, it might be a compelling reason, but it is no longer a work-connected reason. So those are the things that we look at when we walk through all of the steps to determine if someone who has resigned really has a legitimate reason under the Department of Labor rules as to why that person should or should not be eligible for unemployment benefits. So, through no fault of their own, let's talk a little bit about Martha and Ted. Right, so Martha's the front desk clerk. She worked for Ted for just over a year. Martha's chronically late. She never shows up on time. People come to the front desk. They don't know where Martha is. They don't know where to go. They don't know how to call the person that they're looking for. Always late. Well, Ted's finally had enough. He gives us a call and he says, Tracy, I have terminated Martha. I can't stand it anymore. So we said, okay, Ted, how long has this been going on? How long has she been tardy? And he said, from the moment she started working. All right. What did you tell her about being tardy? Did you tell her that it is unacceptable? Did you give her a write-up? Did you give her the work rules that talk about how it's important to be on time for work and how she should report when she's not going to be there? Ted says nothing. So I'm getting a little bit worried. Then Ted tells me, you know what? I hadn't really spoken to Martha directly because she really just ought to know that she needs to be on time or she's going to lose her job. So I let that sink in for a little bit. And then I talked to him and I said, well, Ted, let me tell you, the likelihood is that Martha's going to get unemployment benefits in Georgia. Calls me back a couple of weeks later and he is livid. He's like, I know you told me this was going to happen, but how in the world could she have gotten benefits? This is unbelievable. I cannot believe this. I terminated her for a good reason. It's not my fault that she's always late to work. She's grown up. She ought to know better. And so he wants to know, how is it at all possible that we've got a work rule that says you got to be on time, even though he didn't tell her about the rule, and the unemployment determination is that she gets to have benefits when she's been fired for a good reason. Well, so let's start first with the statutory disqualifications. So under the Georgia rules for the Department of Labor, there are a number of areas where the Department of Labor says, you know what, if you get fired for one of these reasons, the likelihood is that you're not going to qualify for benefits, right? So the first one here says that you violated the absenteeism or tardiness policies. Well, the issue with the Department of Labor is even when you as the employer have a good reason, a legitimate reason for terminating someone's employment, they ought to know better. They should know that they need to be at work on time. They should know that they shouldn't be fighting at work. They should know that they shouldn't come to work under the influence of drugs or alcohol. These are all things that people really should know, right? So, but they do it anyway, and we see this all the time. But the Department of Labor says, yes, these are reasons that will disqualify an employee from benefits, but they're not just going to take our word for it. We actually have to show, as the employer, that the employee knew what the rule was, that they understood what the rule was, that someone said to them from the employer, listen, you are not meeting our standards. You're not meeting our rules. You're not following what our processes are. We can't have someone who engages in the kind of conduct that you engage in. So they want to know that we walk through these steps with the employees. Even when you've got an employee that you've decided just doesn't have the skills or the capacity to do the work, and we file a claim, or the employee files a claim for unemployment benefits, and our response is, well, they couldn't do the job. Let me give you these examples of why they couldn't do the job or how they couldn't do the job. That's what the Department of Labor is asking us to do. They want to know that the employee has been given a fair shot, because the Department of Labor takes the preliminary position that you hired this person, you had control over what that person was doing or not doing on a day-to-day basis. You had the decision-making authority to decide if this person was qualified for the role before you hired them. So once you bring them on, employer, they are your responsibility. You got to walk them through, and if you terminate them, you're going to have to walk us through the reasons why you did that, and that, again, you gave them a fair shot at it. So in Ted's case with Martha, where did Ted go wrong? Well, Ted let Martha go for a year without ever saying anything to her about being late. Martha's response to the Department of Labor is going to be, well, he knew I was late every day. He never said anything. I thought it was okay. I thought it was flexible for me and when I came in. Most people don't think that way, but some people do. And so it is incumbent upon the employer to tell the employee why, what the rule is, how they have not met the requirements of the rule or the expectations of the employment. Even if you don't have a handbook, which you should, but even if you don't have a handbook, if there are expectations for the employment, you've got to tell the employee what those expectations are, and then we document it. We document what we've told them. So the burden is on us as the employer to make sure that we not only give a legitimate reason, but these points that I've said before. The employee knew about the policy or the work rule. They showed that they've been given sufficient time to get it right. Right. So let me talk just for a moment here about, for those of you who might do a probationary period or an introductory period, where you give someone, 30, 60, 90 days to show that they are okay for the job. And the Department of Labor loves that. They love it when you say, listen, we had this introductory period. We wanted them to get comfortable in the role, to understand what was important about their job, to understand what our expectations were, and that we gave them the ability to get it right. We told them what didn't go right. We told them when things were going right and what they needed to do or not do going forward. That's what the Department of Labor wants to see. That's what they want to hear. If you have an introductory period, use it. Exercise it. This is one of those areas where I tell employers all the time, no good deed goes unpunished. It simply does not. If you've got someone who cannot come to work on time in the first 90 days of employment or during that introductory period, they're not ever going to come to work on time. They simply are not. You let them know it's okay to not follow your rule. When you have that introductory period, exercise it. Is it a pain to go find someone else? Yes. Is it a pain to go through the unemployment process? Yes. So pick your burdens, I guess, for what you are doing. If you've got an employee who demonstrates in the first, 30, 60, 90 days of work that they really don't have the capacity or the skills to do the job that you need them to do, use that opportunity to say, this is not working out. Cut your losses and move on. Those are legitimate reasons that the Department of Labor will look at and say, you gave them a fair shot, you told them what they needed to do, we documented what needed to be done, and they still were not able to do it. That burden is on us to show that. It is not on the employee to show that they could do the job. It's on our side to say that they could not do the job or they didn't meet our rules. One other thing that I would tell you with respect to the attendance and the timeliness of work is that the Georgia Department of Labor requires now an employer to have a written notice or policy to employees that poor attendance or excessive tardiness are terminable offenses. And if you don't have that, you've got an even higher burden for the Department of Labor to rule that the employee is not entitled to benefits. So, unemployed through no fault of their own. So I'm just giving you some examples of, what the Department of Labor means by that. It's not my fault that you hired me and I didn't know how to do the work and you let me keep working. It's not my fault that you hired me and I was late to work every day, or I came to work under the influence every day and you let me keep doing it and you did nothing about it. That's what the Department of Labor means by not through no fault of their own. Typically, what we see is unemployment benefits are paid out when there is a reduction in force. That's not through any fault of the employees or that your funding has gone away. That's not through their fault. And most oftentimes, you will have these instances where everyone did everything right, but we still could not continue the employment for reasons, again, that have nothing to do with the employee's fault. And if you are fine with that, then you can let the Department of Labor know, we don't challenge the benefits. We are fine with allowing this person to have the benefits. But if you are going to challenge it, you can't just rely on, it just makes sense to me, or it makes no sense to me that she's going to ask for unemployment benefits. So what I tell folks is don't be a Ted, all right? Don't be a Ted. Don't have a Martha circumstance. What are our preemptive strikes to avoiding that determination? What do we need to do? So the very first thing I tell employers is have a good job description so that there's no question about what it is that I'm asking you to come in and do. And that's particularly important if you've got someone that you're going to terminate because they can't do the job. And so even if you don't have a job description on the front end, at some point early on in the employment, there needs to be a discussion, preferably reduced to writing, that says, here's what your job is. My expectation is that you will be at your desk at 9 a.m. We start getting calls at 9 a.m. My expectation is that you help keep up with the filing. We want to have everything in our files in, whether it's electronic or hard copy. We want it done, last week's filing done by the end of next week. Be very specific about what it is that you want. Follow it up with an email or have the employee take notes so that both of you have a copy of those notes. So there's no question about it. So that's a preemptive strike. So that if on the back end of a situation, whether it's unemployment, whether if you've got enough employees that you qualify for one of the federal anti-discrimination statutes that you're having to defend, these are all the same steps that you want to put in place that put you in the best position as the employer to be able to say, we did what we were supposed to do, the employee did not, the employee was given chances to get it right, they still did not. The employee is not entitled to anything more. So do performance evaluations. Again, if you're ultimately going to terminate someone because they cannot do the job, then we've got to demonstrate why they couldn't do the job or how they couldn't do the job. If you've got disciplinary policies, that whether it's a handbook, whether it's a one-pager that you hand out that says, be on time, you can't fight, you can't do drugs. I mean, it can be very simple, but follow them consistently, because one of the ways that employees go back to the Department of Labor and challenge the benefits is by showing, well, listen, Martha came to work late every day, and Jim came to work late every day. You didn't fire Martha, but you fired Jim. Right? So now we've got a situation where we haven't been consistent in our policies. Jim is filing for unemployment benefits. We challenge those benefits, and Jim says, Martha came in later than me every day. I don't know why I've been fired. And then Jim starts raising questions about, well, why was it me? Right? Are we starting to have a different question that's being asked beyond unemployment? So we want to follow our policies consistently no matter what. Give them time. Don't knee-jerk this reaction to poor performance. Don't knee-jerk this reaction to this person can't show up to work on time. Are there going to be circumstances where you say, you absolutely cannot be here, this absolutely is something that we are not going to put up with? For sure. Fighting, threats of violence, theft, getting into, damage to property, the employer's property, whether it's intentional or unintentional. I'll talk about that in just a moment. But those are all things that we can do on the front end to make sure that when we get to this question of do we have to provide unemployment benefits, that we're able to support our decision. There is a Form 800, it's the Georgia Separation Notice. Technically, that notice is due any time an employee leaves your employment, even if they resign. Technically, it is. Most people only fill it out when the employee has been terminated. Complete that form. And when you complete that form, you give it to the employee. they go and take it to their local county Department of Labor office and file for unemployment benefits. But when you complete the form, be honest about why the person was terminated. Making sure that, if it's that the employee was terminated for violation of your attendance policies, then put it on there. They were absent for 32 days of the last 60 work days. Put it on the form. You're going to get asked more questions anyway at some point, but complete those forms if your intent is to challenge a claim for unemployment. Termination should never be a surprise. It should never be a surprise. Employees will always say, oh no, I didn't know I was going to get fired. Nobody ever told me that. But part of our job is to make sure that we do have those conversations, we do document those conversations, so when that question comes up. Do not rely on verbal communications. People are never going to remember when you've told them that, this can't continue. They're going to tell you, I never heard that before. No one ever told me that. And that just happens. Don't rely on it. You don't have to have an employee sign a document that says it would be nice if they did, that you had this conversation, you told them what the issues were, they've agreed to try to do better. But even if they don't sign it, you can sign it and say, I had this conversation. It happened on May 19, 2021 at 10:37 a.m. Tracy and I talked about the things that she needs to do going forward, and here are the 3 bullet points in particular, and then stick it in your file. If you don't have a moment to do it right then, give yourself a sticky note. Use your phone. Send yourself a message. Shoot yourself an email. Some way to document when that happened, how it happened. And these are just general rules that will help you along the way when you ultimately may have to make a tough decision about having someone's employment end. And then, obviously these well-supported reasons are what we're talking about are as a part of your preemptive strike to avoid a determination that an employee who really deserved to be fired is not entitled to unemployment benefits. So you get the claim. The Department of Labor sends you notification. Most of it is done now electronically, that this person has filed for unemployment benefits, and you're on a fence. So what do you need to know? What do you have to be aware of? Making sure that you provide the correct dates of employment so that they have correct information. This is going to be a record going forward. The compensation earned, that goes back to making sure that this employee is actually eligible for benefits under the Department of Labor rules. And again, the Form 800 asks, did they earn at least $7,300? If you've got an employee that you all have had a mutual agreement to leave, and I get the question a lot, what if I pay severance to somebody? Do they also get to have unemployment benefits? And the answer generally is yes, depending on why they are no longer with the company. And that goes back to those original rules. Would they have qualified otherwise? But what they cannot do is have the severance paid at the same time the unemployment benefits are being paid. So the Department of Labor will ask, is there severance being paid to this employee? And if we tell them yes, they will want to know what is the period of time for the severance, because the unemployment benefits will not kick in until after that severance period has expired. And then again, continuing to be clear about the reasons for the termination. And I want to say, just take a moment here to say, there are many times that I have an employer who says, I don't care if they get unemployment. I'm not trying to stop them from getting unemployment. I don't want to go through this whole process. Can I just, not respond? So there are 2 answers to that. The first answer is it's actually a misdemeanor under Georgia law to not respond to the claims for unemployment. And the State Department of Labor has actually upped the ante a little bit on some of those because, as you can imagine, especially now and over the last year, they've been hit tremendously given the issues with COVID and the closures of a lot of businesses. So, but even before COVID kicked in, there was this sense of people abusing the system. And what they're telling employers is, we don't want you to be a part of that abuse. We want you to give us truthful information. We will make the determination, but you got to tell us what actually happened. Is this person really eligible for benefits? And so they're asking employers, and they are really pushing employers to participate in the process. Are there still times that you may not want to do it? Probably, and we'll hit those on just a moment. The termination reason we've talked about before. Give the names and the titles of the individuals involved in terminating. Again, especially if you are looking at wanting to challenge these benefits. The date, time, and location of the events leading to the termination. These are things that won't necessarily go on the Georgia 800 form, but you will get, once you've completed that initial paperwork, you will get requests from the Department of Labor to provide additional information. Sometimes they'll send it to you by email. Sometimes you'll get a call from one of the examiners to ask you, please tell me why this person was terminated. And then you can go through those. What's really important is not just that the person broke a work rule or they couldn't do the job. What typically is impactful for the Department of Labor is, how does that person's misconduct or inability to do the job impact the business? How does it impact operations? How does it impact other employees? Janice couldn't do her job, and so now I've got to have 2 other people step in and take on Janice's work because she was inefficient, she was unproductive, she doesn't come to work on time. All of those reasons. When the Department of Labor hears those sorts of reasons, they are more inclined to say, you're right. It's not just that they weren't doing the job or they weren't following the rules. It has an impact on the business. It has an impact on other employees. So keep those kinds of things in mind when you're talking about why this person should be disqualified from earning benefits. You have to have a timely response. They'll tell you that on the front end. If you're tardy, they may consider the information, but the bigger issue is, if you are tardy in your initial response to the Department of Labor's request for information, if they give the employee those benefits and you want to appeal those benefits, you may not get an appeal if you were not timely the first time around. And in some circumstances, where they're giving these benefits, the real issue for you is that if every time you've got those benefits, it goes against your unemployment tax rate. And that's where the real money is. That's where you're really paying out more, that you're paying a higher percentage of an employee's, from the employee's wages into that tax system, because your experience ratings, how many times has your organization had to hit the unemployment tax, the unemployment benefits bank, if you will, to pay out someone who's no longer with you. So keep the timeliness in mind. Keep it in mind. Why do you fight? Why do you fight? Again, we get this, and here's some of the reasons why that you may want to do it. If you've got a strong case for showing that their misconduct resulted in the termination, again, that's all of the documentation that we talked about. If you have an instance where an employee was involved in workplace violence, that needs to be a time that you fight and say, we're absolutely terminating someone for that. We don't want that to go away quietly. If you've got someone who was involved in a safety issue, or someone who was involved in theft from your company that is provable, those are times that you might want to fight, because those are very significant issues that you don't want to just slide by. When do employers decide that they don't really want to fight, they want to have an olive branch out to the employee? Well, when you know you haven't really done the documentation to support the claim. Can you at least initially say, this is what we want to do? We don't want them to have benefits, but if you don't have that documentation to support it, acknowledge and recognize on the front end that your claim that their claim for benefits is likely going to be approved, and really consider whether you want to put that kind of time and effort when we know we haven't done what we're supposed to do on the front end. If you've got an employee who has raised other claims, if they have already filed, say, an EEOC charge, or they've already got a complaint with another agency or with a court filing, do you want to deal with unemployment? And there are a couple of risks there with that. One is that as part of the unemployment claims process, there is a hearing. The administrative officer will take sworn testimony. The employee has the right to have someone available with them for that hearing. And as a part of that hearing, they can call witnesses. That can include you. That can include people who may have been involved in the underlying issue that we don't want to have sworn testimony about at this process. We'd rather deal with that in the courts through the litigation process. So that might play into why we do not want to fight a particular claim. If you lose or if the employee loses and they're not allowed the benefits, most employees are going to file an appeal. What do they have to lose at that point? All they got to do is file something with the Department of Labor that says, I want to appeal, at which point it can go up. After the unemployment, the initial claims determination is made, if you file an appeal, you can only base that appeal on the information that was provided at the claims process. So when I talk about having that documentation and providing that documentation, it will only become available to the appeals board if you provided it at the time that you initially are fighting the appeal. You cannot get fighting the claim. You cannot provide the appeals board with any new information. And so that's an important thing to keep in mind if this employee is going to fight an appeal, or if the benefits were provided and you as the employer want to fight the appeal. It's typically this administrative hearing that's very similar to what I talked about before. Keep in mind, again, the timeliness factor. If you get a determination that you don't like as the employer and you say, we've got to fight this, we've got good documentation, we've got good reasons, we cannot allow someone, for example, who stole from us to now turn around and get unemployment benefits, you've got 15 days from the date, 15 calendar days from the date that you get that unemployment determination that they're getting benefits to file your appeal. And the appeals board is very clear about that 15 days. You would have to show fairly extraordinary reasons for why you are not able to meet that 15-day period. Most of these hearings are going to be held for an appeal. The initial appeal is going to be held within 2 to 3 weeks of the date that the notice was filed. And so we need to be ready for that. You got to be ready for that. They're going to last about an hour, and whatever date they give you is the date that they give you. And so keep that in mind when you're looking at that. There are rare circumstances that they're going to be willing to provide a different date. They frankly just have more claims than they have people to deal with them, so they're very stringent about the timing. Excuse me. During the appeals process, any person can bring in a witness, and it would be live testimony. They can bring the relevant documents for the appeal, and you're going to testify under oath. And this goes again back to, what is it that, we're doing, what are we going to say on the front end of this? If you're doing an appeal, we've got to make sure that we have our witnesses in hand, that they are going to be available, and that they have been prepared for this process. They need to understand what the goal is. They need to be able to talk about what their precise role was in the termination. And I would suggest that if you've got in-house or outside counsel who can help get you prepared, do that. There are a number of agencies that will use their outside payroll companies to help help your payroll company make sure that they have the right information. Make sure that they've got the documents. Make sure that if you're going to have a witness, that there's a discussion with that witness before, the 10 minutes that you're going to go into the phone call for the appeal to make sure it's right. And then you can also ask you can find out in advance if they know if there's a lawyer on the other side, because that might make a determination as to whether you want to have counsel present for that appeals hearing, for that sworn testimony that's going to go back and forth. You have the right to have a company representative present for that hearing, whether it's by phone or in person, and exercise that right. You need to have someone, whether they know what's going on or not, available who hears the whole issue, so that there can be good information from that person who can come back to the company and say, here's what I heard during this appeals process. We'll see what happens. I think we should put up a good case. Or now I've got some concerns about what I heard during that appeal that we had not heard before and that we need to look into and be mindful of moving forward. So how do we manage our unemployment costs? So I mentioned before that the real cost of your unemployment claims are those increased taxes and the increased tax rate and those experience ratings. And so keeping those costs down, managing those costs, is something that we have to do by not having as many claims, by challenging the claims that we think we can win, and being very mindful and clear on when we think we've done the right steps to win those challenges. Taking proactive measures. Again, this is one of those things that you can do as a preemptive strike, if you will, that you can do when you're hiring. Only hire the ones that are needed and who are qualified for the job. A lot of times we get into this position of, I just need to fill the job. I just need a warm body. When we can take a little bit more time, if possible, to make sure that we got not just a warm body in the role, but also someone who actually knows what they are doing. Because that will increase your ability to keep somebody around and not have to have this termination of employment. Making sure that we're giving people what they need to know about their job, about their performance on a regular basis, so that we're, again, not getting frustrated and throwing our hands in the air and saying, I can't do this anymore. I can't keep this person here anymore. When we look at it on the front end of who we're bringing in and taking proactive measures, then that helps. But as you are walking through the process of making sure, again, that we're telling the person, we're documenting, we're giving them the opportunity to get it right, and then at that point, if they simply cannot do it and we have to terminate employment, we've now got a record. We've now got the steps that we've gone through to make sure that we can successfully fight that claim for unemployment benefits. And another thing that a number of people will do is that they outsource their unemployment claims to manage the cost. And it may not be the cost of the money, but time for a lot of folks is just as important, if not more important, than dealing with the unemployment claims process itself. So being able to recapture the time might be something that is a good way for you to consider a good way to manage your cost as well. So lastly, quickly, I'm sorry, I realized I see what time it is. The federal American Rescue Plan, the plan that Joe Biden put into place shortly after he came into office, continued to offer benefits on top of what the states were offering for unemployment benefits. Not as much as they were doing in the initial days of COVID, but right now it goes to $300 through the end of September. Well, the states have the option of electing or opting out of that plan. And just a week ago or so, Governor Kemp said that Georgia would no longer participate in the federal pandemic assistance plans. So that means as of June 26, 2021, a little bit more than a month from now, that Georgia is no longer going to provide the additional $300 in weekly unemployment benefits. And you may have people who are currently on those benefits asking, well, why is the money being cut? And that's a decision from the state. The state is saying we're not taking on the liability of this extra money anymore. We're not taking this from the federal government anymore. And a lot of that is, and I'm sure you've heard on the news, that wanting people to go back to work and taking away some of the incentives that people have talked about with these enhanced benefits, what are believed to be the incentives for these enhanced benefits for staying out of work. And so Georgia is saying we're taking that extra money away. We want you to go find a job. We want you to get back to work. As of June 26, 2021, Georgia will no longer permit people who were not otherwise qualified for unemployment. So the rule for years has been if you are self-employed, if you're a gig worker, if you are part-time employees, that you did not get unemployment benefits. And during COVID, however, those groups of people who were otherwise not eligible for unemployment were allowed to get them. And Georgia says at the end of June, we're taking that away. We're not going to extend benefits. So during COVID, during the first part of the COVID extension, the states were allowed to extend benefits because of federal monies that they were accepting to allow the benefits to go longer. So typically it could be 13 to 26 weeks. They were extending it up to 39 weeks in many places. And then Georgia's also not going to provide the additional $100 for people in what we call mixed earnings. Doesn't apply to most people, but I wanted to make sure you had that information anyway. So that is, I believe, the end of my comments. Hopefully it has gotten you up to date on what you need to know on unemployment benefits in Georgia. So I'm happy to answer any questions. Surisha?
Yes, we have one question from the audience. Sherry is wondering if the nonprofit has a clear written policy with a 90-day training period or probationary period. If the organization decides to terminate the employment during that 90-day period, is there still a possibility that person could be eligible for unemployment?
It depends on the reasons why the termination is occurring. Generally the Department of Labor would say, if you didn't make it through the 90-day introductory period, they'll want to know why. Was the employee not really qualified for the job? Did they have other reasons why they could not do the work? But they typically are willing to give that 90-day probationary period, give the employer a little bit of a nod for that. You've told the employee we're going to see how it works out during this 90 days. We're not promising you the full 90 days. We're not promising you a job after day 91. But they still want to know what is the reason why that employee is not going to continue in their employment. But they do give some credit, if you will, to an introductory period. So okay. All of that to say, in many instances, yes, the Department of Labor will look at it and say you didn't make it through your 90-day period, you're not entitled to benefits, but it is up to the employer to still say why they didn't make it through that 90-day period. That's clear.
Okay. And a question about if a nonprofit opts to be a reimbursable employer, how does that reimbursement work in terms of timing? If an employee is terminated and then they're eligible and make a claim, and then at that point, does the nonprofit have to pay quarterly, yearly? You work out an agreement with the Department of Labor. Yeah, okay. You work out that agreement with them on the front end. When you go into it and say, I want to be a reimbursable employer, then you work with them on agreement
as to what that means in terms of how long that reimbursement will take place. It could be quarterly, it could be biannually. You just work that out with the Department of Labor.
Okay. Well, I don't see any more questions, Tracy. This has been fantastic information. I really appreciate you taking the time to share all of this information with us. And to our audience who tuned in today, thanks for joining us today.
Thank you all. Good luck. Bye-bye.
Bye.